Morning, everyone. So happy that you could join us. We have a pretty small group, like Brittany said, so just make this more of a conversation. So this is the first of our top 10 document webinar series. Today, we're talking about grievance procedures. The next one will be about notices of non-discrimination, and then the third will be about website accessibility. So we hope that you'll join us for all three. With that, I'm going to go ahead and get started. So as Brittany said, I'm Tasha Allen. I am the Senior Director for Career and Technical Education here at the Community College Board. I'm also the State Post-Secondary Methods of Administration Coordinator, and I will talk here momentarily about what that means. Okay, so before we dive into the grievance procedures themselves, you might be wondering why ICCB is putting on professional development about grievance procedures in the first place. So just a little bit of background. So we are mandated by the U.S. Department of Education Office for Civil Rights, which I will refer to as the OCR from now on, to conduct periodic compliance reviews. And I have compliance in quotations on the screen because they're more of like technical assistance visits of Illinois Community College CTE programs to ensure that they're complying with federal civil rights laws. So the Methods of Administration, or MOA program, is what gives ICCB and other state agencies this authority. The MOA framework was laid out in the vocational education guidelines. It has a much longer title than that. So if you are interested in specifically what that title is, just shoot me a quick email or type it in the chat and I can post it in there at the end of the presentation. But from now on, I'll refer to them as the guidelines just for ease of speaking. So the purpose of the MOA program is to ensure that all students, regardless of race, color, national origin, sex, or disability, have equitable access to high-quality CTE programs. These technical assistance or compliance reviews that we do affect all different areas on campus. So admissions, advising, facilities. So actually doing reviews of more like the physical accessibility side of things, like restrooms and stairwells and that type of thing. And also marketing. So some of the examples of what we review to see if an institution is in compliance are the notices of non-discrimination, and that's typically that statement that's posted on the website, recruitment materials, the college catalog, grievance procedures, cooperative agreements, etc. So today, as I said, we will be talking about grievance procedures. Oh, before we get into that, excuse me. So in addition to the guidelines, which do establish the MOA's programs authority, we also review compliance with Title VI of the Civil Rights Act of 1964, and that prohibits discrimination against race, color, and national origin. Title IX of the Education Amendments of 1972, and I'm sure most of you are probably familiar with that legislation that prohibits discrimination against sex. Section 504 of the Rehab Act of 1973, and Title II of the ADA, both prohibit discrimination against disability. Okay, so even though I can't see you because I'm presenting, show of hands, or you can use your little emojis or something. Has anyone seen any of these documents? Okay, I'm not seeing anything, so I'm assuming, oh, someone's typing in the chat. No, first time I've seen them. Okay. So probably about 5 or 6 years ago, Brittany, correct me if I'm wrong, that was definitely before Perkins 5. We worked with ICSPS to create these top 10 documents. And these really came about because we would do these civil rights reviews and we would see the same things over and over and over and over again. And it's not because the colleges wanted to be out of compliance or it was malicious or anything like that. It was the requirements based on law are so specific. So if you don't go to the legislation and look at what's required, you're not going to necessarily know. So everything was in good faith, but there were certain things that we were finding that we kept giving recommendations to fix. And so we thought, let's make some documents so we can easily provide them to the colleges and say, okay, top 10, here's what you need to know for grievance procedures. Top 10, here's what you need to know about notices of non-discrimination, etc. Excuse me. So, Brittany, do you want to post in the chat? I don't know if you already did, the link to the grievance procedures so everybody can follow along if they want. The
Yeah,
link
so
to the top 10.
the PDF for the top 10 grievance procedures is in the chat, but I will also post the link for the resource page where you can find all 3 of those documents, as well as we also have a secondary version of the grievance procedures, because that is different. And we, you know, while many of you are not secondary focused, it's always nice to have that information as well. So I'll post that in here momentarily.
Thanks, Brittany. Yes, I should have said earlier. So the State Board of Education also does civil rights reviews, but obviously they do them at the secondary institutions. So they do their thing and we do our thing. All right, so we're going to dive into the actual grievance procedures themselves. So I wanted to make sure to provide you with the sources of the requirement for the grievance procedures. So the MOA guidelines don't lay out anything specific to grievance procedures, but Title IX and Section 504 both do. So again, Title IX is about sex discrimination, and Section 504 is about disability discrimination, and you'll see why those are the two that are the ones that lay out the requirements. Okay. All right, so the rest of the presentation is going to go through the grievance procedure, the top 10 document. So Brittany posted this in the chat. So if you want to follow along on your computer, please feel free. If not, you don't have to. But that's how the rest of the presentation will be laid out. So number 1, we're talking about disseminating the grievance procedures. So institutions are required to disseminate grievance procedures to all students and employees. Typically, how we see this done in today's digital age is by posting them on the website, which is great. That's fine. That's allowable. Make sure that they are accessible and easily searchable. So if someone has to look for 15 minutes to find the grievance procedures, that probably means they're not easily accessible or searchable. You can also post them or put them in the student handbook or employee guidebook, employee manual, whatever you call it at your institution, or provide them at some sort of faculty or student orientation. Now, with that being said, we've all been students before. You know, when you receive a wealth of information, sometimes things tend to go in one ear and out the other. So if someone might have good intentions to say, here's the grievance procedures for if you feel like you've been sexually harassed, or if you feel like you've been discriminated against, these are those grievance procedures. And you take the information and say, okay, well, you don't really need it until you need it. So that's why it's really kind of a best practice to make sure they're at least on the website somewhere that someone can easily access them. All right, number 2 is about having multiple procedures. So institutions are allowed to have multiple forms of grievance procedures. They don't have to have a specific name, so they don't have to say Title IX grievance procedures or racial discrimination grievance procedures, nothing like that. But at the same time, it has to be clear when each procedure is to be used. So if on the surface you're looking at 2 that are for completely different purposes, they might look the same, but they're for different things. So just make it clear that this is the procedure you use for disability discrimination. This is the procedure you use for complaints of sexual harassment, etc. And I meant to say on the last slide, I knew there was something else that I was forgetting. So when we're talking about grievance procedures, I want you to think of grievance procedures in terms of someone placing a grievance against someone else for, again, like sexual harassment, discrimination, really serious issues. We're not talking about like academic grievances, like a student is upset about their grade or something like that. That's a completely separate thing. This is specifically regarding civil rights issues, right? So I just wanted to lay that out there so there's no confusion. So Institutions are required to have a grievance procedure or procedures that deal with complaints of a sexual nature, so harassment or violence, and disability discrimination. So you are required to have grievance procedures for those two things. You are not required to, but it is a best practice to have, adopt, and publish procedures for resolving complaints of discrimination based on race, color, and national origin as well. So those procedures that address complaints of sexual harassment, violence, or disability discrimination must follow the prompt and equitable standards. So this is one of the things that we got so many questions on, rightfully so, because it's a little bit subjective, right? So how the OCR evaluates prompt and equitable standards historically, there are several different things that they look for. Providing adequate, reliable, and impartial investigations, designating and following reasonably prompt timeframes. So again, that's a little bit subjective, but we'll get to that in a second. Making sure that you're providing notice to both the complainant and the respondent of any particular grievance. So just making sure that everything is equitable in terms of if one party gets it, the other party gets it. And again, we'll get into this in a little more depth here in a couple more slides. Okay. There's something I was going to say, I don't remember. All right. Okay, so numbers 3, 4, and 5 in the top 10 doc deal with both parties receiving equal processes. So this is what we were just talking about, going a little more in depth here. So institutions must provide grievance procedures that provide due process and equal rights for both the complainant and the respondent. It cannot favor one party over the other. It must provide equal rules of evidence, right to review evidence, and timely access to information for both parties. Additionally, if one party requests an appeal, access to an attorney, or requests expert testimony, it must be allowed for both parties. And the procedures must provide both parties with the same timeline and inform them that they will receive written determinations. So timelines we'll get into here in the next slide, actually. But I wanted to take a quick step back. So when we're talking about prompt and equitable timeframes, so if you're thinking about dealing with a complaint of a sexual nature, right? That's something that you're going to want to address fairly quickly. So just keep that in mind as we come up here to the next slide. Okay, so number 6 on the top 10 doc is about timelines. So grievance procedure timelines must include the following: the period or length of time in which the parties will be notified of the complaint. So obviously the complainant is going to be aware that they're filing a grievance, but the respondent is not going to be aware until they are made aware. So making sure that time frame is not long. Again, especially if you're dealing with a complaint of a sexual nature, the complainant could possibly have classes with the respondent. They could possibly be on a similar sports team, something like that. So someone that they are around often enough to make one party feel uncomfortable. So making sure you're responding to things quickly. The procedure timelines must include the period of time in which the institution will conduct a full investigation. So what that looks like could be different depending on the complaint or grievance, could be different depending on the institution. I would personally say probably to conduct a full investigation, no more than 60 days. Especially, again, I keep going back to complaints of a sexual nature, but they really are different than any other complaint. So making sure you're giving due process to both parties, I mean, the complainant and the respondent, you want to make sure the issue is resolved and there's some sort of next steps as quickly as possible, right? And also must provide a timeline for the deadline for appeals if it is applicable. Okay, so number 7 and 8 deal with both informal and formal grievance processes. So the procedures may provide for both informal and formal grievance processes. So when we're talking about informal, it's more like, so part of the grievance procedure could say, okay, depending on what your grievance is about, you can go talk to the person who you have a complaint with, or you can meet off campus or just something more informal. So that can be included in the procedure, but it needs to be very clear that the complainant can end the informal process at any time and begin the formal process, or they can skip the informal process altogether, or there doesn't have to be an informal process. That's not a requirement. But if there is a more informal process, it must be clear that this is the informal process, this is the formal process. You can end the informal process at any time, no questions asked. Again, especially when we're talking about complaints of a sexual nature. Procedures cannot require an informal process or mediation between the complainant and respondent, especially regarding complaints of sexual harassment or violence. So if at your institution, your grievance process is you have to do the informal process before going into the formal process, you cannot require that when you're talking about a grievance of a sexual nature. You cannot require someone to sit across from somebody who has lodged a complaint against them for sexual harassment, violence, assault, anything like that. Accommodations must also be made to ensure that both parties are not forced to appear together at the same location at the same time. All right, so number 9 deals with requirements for the formal process. And this is a little bit different than what it is on the document. So if you remember from the beginning of the presentation, it's been a while since these were updated. We've undergone some administration changes at the federal level. And so some of these processes have been changed and adapted and reflect some of those changes in administration. So number 9 on the sheet, if you're following along, is a little bit different than what I'm going to go over now. What I'm going to go over now is a little bit more specific than what it is on the sheet. So again, these are the requirements for the formal process, and this is about sexual harassment and violence and disability discrimination. Okay, so number 1, treating parties equitably. The school's grievance process must treat the complainants and respondents equitably, again, by providing remedies to a complainant if a respondent is found responsible for something, and by following the prescribed grievance process. Okay, so making sure that both parties receive equitable treatment. Objective evaluation of evidence. So this is a fancy way of saying that you can't determine someone's credibility on the basis of their status as a complainant or respondent or witness. So essentially, you can't discriminate against someone if they're the complainant or if they're the respondent. The next one, making sure that the individuals who are handling these grievances have been properly trained, and also making sure that there are no conflicts of interest. Let's see. Number 4 is the presumption of innocence. So just like in court, you're innocent until proven guilty. The same goes for grievances. There also must be reasonably prompt timeframes. So prompt and equitable, those are really the key words when we're talking about grievance procedures, as you probably discovered by now. So the grievance process, again, must include reasonably prompt timeframes for resolving formal complaints of sexual harassment. Temporary delays are permitted, but only for a good cause. And again, that's very subjective, but that is what the law says. Okay, number 6 is the description of a range of outcomes. So the process must describe or list the range of possible remedies or disciplinary sanctions that could occur following the determination of responsibility. So if the respondent is determined after the conclusion of the investigation, it's determined that they are found guilty, before that happens, everyone must be informed of the possible disciplinary actions that could be taken against that person. So the standard of evidence. So on your sheet, if you're following along, number 9 talks about specifically using the preponderance of evidence standard. So it's been updated to reflect you can either use the preponderance of evidence standard or the clear and convincing evidence standard. So the right to appeal, again, either party has the right to appeal. It must be made known within the grievance procedures that is a something that both can do. Description of range of supportive measures. So this is about the process describing what measures are provided to both the complainant and the respondent in the interim of the investigation of the complaint. So what, again, whether it's if they're in the same class or if they're on the same team, making sure that you're providing both parties, here's what we can do to support you during this investigation, and laying that out for both parties and making sure that they're both aware of the different supportive measures that are available to them. And number 10 is preserving legal privileges. Pardon me, preserving legal privileges. So the school's grievance process must explain that no information protected by a legal privilege, such as the attorney-client privilege or the doctor-patient privilege, can be used during an investigation unless the person holding that privilege has waived it. All right, and number 10, filing with the federal government. So the grievance procedures should inform the community or those that are using the grievance procedures that at any point they may file a complaint with the OCR. And our regional office for OCR is in Chicago. We actually have had them to present at a training years ago at this point. Okay, so looks like we're getting pretty close to time. I'm a little long-winded, I'm sorry. And I want to make sure we get to this activity that I have planned. So let's do that. And then if anyone has any questions or anything, I can open it up for discussion. I just want to be mindful of everyone's time. Okay, so this is a scenario game that I like to play whenever we do these trainings. We've done, I don't know how many of these trainings at this point. So I'm going to read you a scenario. I want you to think about it for a couple seconds, and then I would go ahead and unmute. That might make it easier than trying to pop your answers into the chat, but you can do whatever you're comfortable with. So this is a scenario of a grievance, and I want you to, I'm going to read it to you. If you think that it's good to go, you can say good to go. I don't see any problems there. If you do see problems, note those problems and we can share that. Okay. All right. A student, the complainant, has filed a sex discrimination grievance against another student, the respondent, a student athlete. The complainant has accused the respondent of sexual assault. The complainant was unable to find the procedures on the website or in the student handbook, so they took the complaint to one of their instructors, unsure of how to proceed. The college's athletic director was made aware of the complaint and then told the complainant that before the grievance process can begin, the complainant must meet with the respondent to attempt to resolve the matter informally. Notes made by the athletic director state that the complainant is probably lying. If the aforementioned meeting fails to adequately resolve the matter, the grievance process would move to the formal stage. There is typically a 120-day period between the informal and formal stages. During the formal stage, the respondent is able to provide evidence, witnesses, etc., to rebut the grievance. Within 1 year of the initiation of the formal stage, both the athletic director and the college's head football coach shall complete the investigation and determine the appropriate course of action, allowing the respondent the right to appeal if necessary. Written notice of the investigation outcome will be provided to the respondent.
Hi, this is Tasha Jones from Richland Community College. there's a couple things. I'm not certain that it would be wise for the athletic director to have the student speak to the individual that they're saying has caused harm to them. I don't think that that's appropriate. And I also am concerned with this 120-day period. That seems to be an awful long time to me.
Thank you, Tasha. Anybody else? If you think it's good to go, I won't judge you. Nobody else wants to speak up? Okay, I will say that I updated the scenario a little bit after I had initially typed it out in here, but I only updated it in the answer. So it's going to look slightly different, but the spirit is the same. Okay. All right. So one issue is that both parties must be allowed to produce witnesses, provide evidence, etc. So this says the respondent is able to provide evidence and witnesses, but it doesn't say anything about the complainant also being able to provide witnesses. Both parties must be able to provide witnesses, testimony, etc. So that's one issue. Another issue, the informal stage is always voluntary, never a must, and must be agreed upon by both parties. So this is something that Tasha pointed out. And I have a little note in italics there. The informal stage is typically not appropriate involving allegations of sexual misconduct. It should probably be avoided. All right. Again, as Tasha pointed out, the college has laid out the timeline, which is good. It specifically states the timeline, which is required. However, it's not prompt or equitable to either party. The 120-day period is way too long. They're saying that in between the informal and formal stages, there's a 120-day period between those two things. Also, it's saying within 1 year of the initiation of the formal stage, the investigation will be concluded. That is way too long, especially when you're talking about a complaint of a sexual nature. So written notice of the investigation outcome must be provided to both parties. Again, this says the outcome will be provided to the respondent, but it needs to be provided to both parties. The procedure should easily be accessible and searchable on the website or in the handbook. And this says that the student was not able to find them on the website or in the handbook. So make sure those are prominent, if not prominent, easily findable and accessible for someone when they need them. So you must provide an objective evaluation of evidence. Credibility determinations can't be made on the basis of a person's status as a complainant, respondent, or witness. So the athletic director states that the complainant is probably lying. So already going into that situation with a bias. Speaking of the athletic director, unless this person has received appropriate training, and the athletic director could be the Title IX coordinator, it's not advisable that they are, especially when we're talking about someone who's a student athlete. So that is a conflict of interest. Even if this athletic director is completely impartial, doesn't know the student athlete from anyone else, it's still an appearance of a conflict of interest. So that would not be an appropriate person to be handling this complaint, especially since they are saying that the complainant must meet with the respondent before we go into the formal process. And since they are doing the investigation as well. So that's not appropriate. Also, the presumption of innocence. So this is where I said I forgot to update the other scenario. I apologize. So when I rewrote it, I put the Title IX coordinator in here. So the Title IX coordinator assumes that the respondent is guilty. So the athletic director is saying that the complainant is lying, but the Title IX coordinator is already going into it thinking that the respondent is guilty. Everyone deserves the presumption of innocence before the investigation has gotten underway and is concluded. All right. So we don't have time to go over the website, but I just wanted to make sure to put this in here. This is our Illinois Civil Rights Review website, and there are a lot of nice resources, including these documents. So please check that out, and we will send this presentation out. I don't know if we'll wait to send it out, all three of them at the same time. I haven't talked to Brittany about that, but. So I mentioned earlier, so this is the first in our webinar series. The second one is on the 9th of February, and that's about notices of non-discrimination. Again, that's another area that we receive so many questions on when we do these on-site visits. And the third is about web accessibility. Now, I wanted to note that web accessibility is not something that's under the MOA guidelines. The MOA guidelines were written in 1979. So web accessibility wasn't a thing, but this is something we always get questions on. And so we went ahead and made a top 10 document for this as well. So that will be on March 21st. Again, it's just going to be a little 30-minute quick webinar. If you have any questions, I would be happy to answer them, or you can email me on the side or call. This is my email and phone number. And then I also put Brittany's email and phone number as well.